Flammur Schala Fokusstrategie Mittwoch 19. Januar 2022. Press release: The International Criminal Tribunal hands down its first sentence, 10 years of imprisonment for Drazen Erdemovic. 1.3. So we are at point 1, applicable law and principles. We saw 1.1, the scale of penalties applicable when an accused is found guilty of a crime against humanity. 1.2, the principles governing sentencing. 1.3, enforcement of the sentence. One of the major difficulties with which the International Tribunal has to contend relates to the place and form of execution of the sentence. In the light of the pertinent texts, the trial chamber notes that enforcement relies on the designation of a state and on the tribunal's supervision of the conditions of imprisonment enforced on the state's territory. The trial chamber accordingly considers that it is for the registrar, upon consultation with the president of the International Tribunal and with the approval of the presiding judge of the trial chamber, which delivered the sentence, to designate the state where the imprisonment will be served. The trial chamber intends, however, to take account of the matter of place and conditions of execution of the sentence. In an effort to ensure due process, the proper administration of justice and equal treatment for convicted persons. Every accused should in fact know the possible consequences of a conviction for an international crime. A certain level of uniformity must be upheld in the enforcement of sentences, irrespective of the state in which the sentence is served. Lastly, the trial chamber feels it incumbent to provide some guidance in respect of the enforcement of international judgments. In this regard, the trial chamber feels it incumbent to provide some guidance in respect of the enforcement of international judgments. In this regard, the trial chamber considers that, pursuant to the principle of equality before the law, there must not be any major disparities from one state to another in the enforcement of sentences. It therefore recommends a certain degree of uniformity and consistency in the enforcement of international criminal sentences. There are two concerns it believes are essential in the light of the international character of the penalty: respect for the duration of the sentence and respect for international standards relative to the treatment of prisoners. As regards duration, no measure shall be taken by a state which might terminate the sentence or alter it by reducing it. As regards the treatment of prisoners under the statute and the rules, the tribunal has some powers regarding the treatment of convicted persons. The trial chamber considers that the penalty imposed and its execution must always comply with the principles of humanity and dignity at the heart of the international standards for the protection of the rights of prisoners. Having specified its legal framework, The trial chamber will now analyze the criminal acts as submitted to it in the indictment against Drazen Erdemovic and the circumstances leading to their commission, with a view to determining the most appropriate sentence. 2. The case in point. The trial chamber first set out the relevant facts of the case and then considers their probative value, in particular from the angle of the mitigating circumstances invoked by the accused. 1. The relevant acts, or 2.1. The relevant acts. The trial chamber would recall that the acts with which Drazen Erdemovic is charged occurred in the context of the events which followed the fall of the enclave of Srebrenica. Those events were attested to publicly during the hearing pursuant to Rule 61 in the prosecutor's cases against Radovan Karadzic and Ratko Mladic. The acts involved would implicate those indictees in the commission of crimes against humanity and have been corroborated by many statements, including the testimony of the accused. They were further corroborated by him during his guilty plea. They are outlined below. According to the public testimony of the investigator of the prosecutor's office, the sites of the massacres with which the accused is charged have been identified, thus corroborating the accused's own statements. First, there is the Branievo farm at Pilica, where approximately 1,200 Muslims were executed by soldiers of the unit of which Drazen Erdemovic was a member, an involvement to which he admitted. Then there is the public building in Pilica where, according to the public testimony of the accused, approximately 500 Muslims were executed by members of the 10th sabotage unit. As regards the acts with which Drazen Erdemovic is charged, the trial chamber has reviewed them as they were set forth in the indictment and formally recognized by the accused when he entered his plea of guilty and subsequently elaborated on at the hearing. They will not be addressed in this summary. The trial chamber has endeavored in particular to address these acts from the angle of the gravity of the crime committed and the mitigating circumstances invoked by the accused. In the sentencing procedure, that discussion will be the prime support of the line of reasoning behind the sentence. 2.2. Gravity of the acts and mitigating circumstances. The trial chamber considers that the crime's extreme gravity has been demonstrated. Participation in the murder of 1,200 unarmed civilians over a 5-hour period on 16 July 1995. So on 16 July. 1995. Within 5 hours, that's 5 times 60 minutes, 300 minutes. There were murdered 1,200 civilians, unarmed. means 4 per minute. 4 humans per minute, meaning 1 in 15 seconds. According to his many affirmations, Drazen Erdemovic is responsible for the murder of from 10 to 100 people. So he killed 10, between 10 and 100. As regards mitigating circumstances, the trial chamber has distinguished 2 categories. 1, those which were contemporary with the perpetration of the criminal act, that is, the mental incapacity of the accused, the urgent necessity he was allegedly in at the time he committed those acts, as well as his low military rank, and 2, those relating to the accused's attitude after the commission of the acts, that is, the contrition he showed, his willingness to surrender to the International Tribunal, and his cooperation with the office of the prosecutor. Lastly, the trial chamber discussed certain aspects of the personality of Drazen Erdemovic as elucidated by his testimony. And the public testimony of witnesses X and Y, and the closing arguments of his defense counsel. So A. Mitigating circumstances contemporary with the perpetration of the criminal act. Criminal act mitigating circumstances. I abbreviated to mitigating circumstances, or I shorten it to mitigating circumstances. I, or 1. The trial chamber has not accepted the line of argument of the defense regarding the mental condition of the accused at the time of the acts. There is nothing in the case file or in the experts' reports which enables conclusions to be drawn in respect of the accused's psychological state at the time of the crime. I. Or 2. Urgent necessity stemming from duress and the superior order. So, first point was, I will just read it. It's about duress now. To assess its probative value, the trial chamber identified a number of questions. Could the accused have avoided the situation he was in? Then, another question. Was the accused confronted with an insurmountable order he had no way of eluding? Another question, or third question. Were the accused or close members of his family exposed to the danger of immediate or short-term death? And fourth question. Did the accused have no moral choice to oppose the orders he received, or if he had, did he attempt to oppose those orders? The trial chamber noted that the overall account of events by the accused could be considered quite likely to have happened. It is also aware of the general atmosphere prevailing at Srebrenica at the time the enclave fell and when the ensuing events occurred. However, in respect of the acts involving the person of the accused, which might be a basis for allowing mitigating circumstances, the defense has provided no testimony expertise or other element to corroborate with Drazen Erdemovic said. Bestätigen. Corroborate. Accordingly, the judges considered themselves unable to accept a defense of urgent necessity. III, or 3. Low military rank. According to him, Drazen Erdemovic was a sergeant and as such was in command of a small unit. He was allegedly demoted before committing the crimes with which he is charged, but no document clearly establishes his military rank. The indictment in which the accused pleaded guilty describes him as a soldier in the 10th Sabotage Unit. The trial chamber considers that Drazen Erdemovic, described by the prosecutor as a low-ranking member of the Bosnian Serb army, did not hold a position of authority at the time of the said crimes. Now B. So it's the case in point 2.2, gravity of the acts and mitigating circumstances. We saw now the mitigating circumstances. A was contemporary with the perpetration of the criminal act, and now B is mitigating circumstances relating to the attitude of the accused after the commission of the acts. Attitude afterwards. Attitude afterwards. I, or 1. Remorse and the willingness to surrender. Drazen Erdemovic's remorse for the crimes he committed is evident through his statements, his conduct, and the report of the medical reports. And I will just continue after 1 second. So again, remorse and the willingness to surrender. Drazen Erdemovic's remorse for the crimes he committed is evident through his statements, his conduct, and the report of the medical experts. The trial chamber notes the constancy with which the accused has unequivocally and spontaneously expressed his responsibility in the massacre of Branjevo farm, and his contrition therefore. Reue. The desire to clear his conscience, la conscience, was expressed by his willingness to surrender to the International Tribunal to answer for his crimes, and in his plea of guilty. The medical experts noted the state of depression in which he arrived at The Hague, accompanied by a feeling of guilt. In determining the penalty, the trial chamber accepts the remorse expressed by the accused. II, or 2. Cooperation with the officer of the prosecutor. Cooperation with the officer of the prosecutor. The prosecutor has referred repeatedly to the cooperation of the accused, which he characterized as substantial, full, and unconditional. The prosecutor revealed that without the accused's statement, he would not have been cognizant of 4 events, including the massacres at the Branjevo farm and in the public building at Pilica. Other information provided by Drazen Erdemovic has permitted the prosecution to gain a better understanding of the geographic area where the massacres occurred, the logistic resources deployed, and the names and identity of a number of the individuals responsible for these acts. The accused gave essential testimony in the hearings against Radovan Karadzic and Ratko Mladic. The trial chamber considers that the accused's cooperation with the office of the prosecutor must be accorded considerable significance in mitigating the penalty. C. Aspects of the accused's personality. Aspects of point personality. There's a personality of the accused. The trial chamber heard the accused on the subject of his childhood, schooling and professional training, and present family situation. It noted the statements of defense witnesses X and Y, and acquainted. Become acquainted. It noted the statements of defense witnesses X and Y, and acquainted itself with the findings of the medical experts. On the basis of these elements taken as a whole, the trial chamber deems it appropriate to give special consideration to the relative youth of the accused at the time of the crimes. His present family situation, the fact that he does not pose a threat, his gesture in rescuing witness X, and the series of features characterizing of corrigible personality. Having considered all of the facts of the case submitted for its attention, the trial chamber is of the conviction that, given the inherent gravity of his crime, it is appropriate to grant Drazen Erdemovic the benefit of the following mitigating circumstances. His age at the time the crimes were committed, and his low military rank. The remorse he expressed, his willingness to surrender, and the cooperation he has provided to the officer of the prosecutor. The fact that he does not pose a threat and has a corrigible personality. Trial Chamber 1. For these reasons, delivering its judgment publicly in the presence of the parties and in first instance, pursuant to Article 23, 24 and 27 of the Statute and Rules 100, 101 and 103 of the Rules of Procedure and Evidence, noting the indictment as confirmed on 29 May 1996, noting the plea of guilty by Drazen Erdemovic on 31 May 1996 to the count of crime against humanity as provided under Article 5A of the Statute, noting the briefs of the parties, having heard the closing arguments of the prosecution and of the defense, in punishment of said crime, sentences Drazen Erdemovic, born on 25 November 1971 at Tuzla, to 10 years imprisonment, and rules that from the total duration of this sentence shall be deducted the period during which the convicted person was in custody and provisional detention pending his transfer to the International Tribunal and his judgment by this trial chamber, that is from 3 March 1996 until today. Rules that the registry shall, upon consultation with the President of the International Tribunal and with the approval of the presiding judge of this trial chamber, designate the state where the sentence will be served, and rules that this judgment shall be enforceable immediately, done in French and in English, the French text being authentic on 29 November 1996, The Hague, the Netherlands. So the text you heard now was, or the text I read was a translation from the French language. The original is in French language, so there might happen that there are errors errors in the translation, but usually it's the same meaning. It's correct and it's the same meaning. So, das ist jetzt ein weiterer Text gewesen. Ich habe das Gefühl, das wird sogar in der Playlist einer der ersten Texte sein, 1996, 29. November 1996 in Den Haag, Niederlande oder Holland. Ich werde auch weitere Press Release und Judgments einlesen und die Playlist ICTY Schritt für Schritt erweitern.